Hi, I'm Steve Richardson, and this is the May 2019 episode of Lunch with a Lawyer. And today we're going to talk about how to deal with debt collectors. Now, hopefully, this won't be of interest to you. You're in good financial shape. You're not struggling with bills. You can move on. I understand. You don't have to watch. This isn't something that pertains to you. However, if you know somebody that might benefit from this information, please be sure to maybe share the video on Facebook with someone. I'll mention sharing a little bit later towards the end of the show, but share it with them on their Facebook page. You can also share it with them privately on Messenger. You may not, considering the topic, want to just put it on their wall. You can discreetly share it with them on Facebook Messenger. Also, this Lunch with a Lawyer also gets put out to my YouTube channel at richardsonlawoffices.tv. You can certainly just send them the YouTube link and say, hey, you might want to watch this, good information. So, dealing with debt collectors. Now, this can be a very stressful situation. You get behind your bills, phone starts ringing, you start getting a lot more mail, and you might have a tendency or a desire to just stick your head in the sand and hope it'll all go away. Well, that unfortunately is the first mistake. Something you shouldn't do is ignore it. Don't ignore the calls. Don't round file their letters when they come in. You know there's a problem with the debt. You know they're trying to collect it. Address it. Deal with it. Take the bull by the horns, and do that. So that's the first thing. Because a lot of times, and I've seen this, sometimes the debt collectors will offer you a deal and say, look, you owe this much, but I'll tell you what, if you pay us this much, we'll call it even. Okay. So they may be telling you something helpful. So don't ignore the letters. Okay. Be proactive. Do something about it. As I said, don't ignore it, but do take action, the opposite. Do something about it. Reach out to them. The sooner you make some sort of deal, the better. And just make some sort of affordable payment. Even if it's only temporary for a little bit until you can see, what else you have to do with it, if you have other creditors or things you have to do. Now, there is a caveat to that in making payments, and you're going to want to take a stop, look, and listen on this. When the debt collector calls you, say, what debt is this? Who's the creditor? And take a look at it and see how old it is. Okay. Check your credit report. Is it still on your credit report? Things have to come off a credit report under the Federal Fair Credit Reporting Act under 7 or 7.5 years. Okay, and then it becomes ancient credit history and it comes off. The statute of limitations in New Jersey to collect debt is 6 years. So if it's come off your credit report, then it's older than 7 years, and you're in New Jersey and there's an issue as to whether they can even sue you or even try to collect from you because it's too old. It's past the statute of limitations. So there may be defense there. If they're calling and you don't recognize the name of the creditor, they may say, well, we're calling on behalf of Midland Funding, not to pick on Midland Funding, or LVNV Financial, or Cavalry Portfolio Services. These are all debt buyers. The industry of collections changed over the years. When I first started doing creditor collections, the creditor would try and collect it, then send it to a collection agency to collect, and the collection agency would then send it out to a law firm to bring suit to collect it, and that's what was done. These days, creditors are more often than not just selling the debt, saying never mind, I don't want to go through the trouble of having to collect it. I'd rather have less money now, sell it at a discount, and have the debt buyer then turn around and try and collect it in full so they make their profit. So you may not recognize the creditor from the name. So if they call or contact you, the debt collector, tell them you want a verification of debt and that you want to know who the original creditor was, and you want that notification in writing. Then, once you know that original creditor, go back to step one. Check your credit reports, all 3 credit reports, not just one, okay? Because they may not have been reported to all 3. So check Experian, Equifax, and TransUnion and make sure, because it may be too old. And why I bring this up now is if you make a payment on this, you run the risk of resetting the clock on the statute of limitations. Oh, we made a deal. You know, we got a deal in place. You made some payments, and then you breached that deal. And you can end up resetting that. So before you make any payment arrangements, before you do anything, the first thing you want to do is find out how old the debt is. Because if the debt is too old to collect, then they may not be able to collect from you. The best thing to do is, if you suspect it's too old, if you've done the investigation that I've suggested, is consult with an attorney and find out. Go over it with him or her. I talk to people about stuff like this here in Southern New Jersey. People come to me and we look at the debt and say, is it past statute of limitations? Can they collect it? That's something to bear in mind. So that's a step to take before you start making a deal. So going forward, assuming that this is a fairly recent debt, and within the statute of limitations, they can collect it. Again, it's best to try and work something out if you can. Now, in dealing with the debt collectors, there are certain things that you need to know, because it can be a very stressful situation. Debt collectors can be very intimidating, but don't take their crap, okay? Just saying. There are things they can't do. They can't, no matter how much they may threaten, all right, they can't say, we're going to levy your bank account or garnish your wages if you don't pay by Thursday, all right? Common tactic. Don't believe it, all right? If a debt collector is telling you that, it's a lie, okay? A law firm, if it's with a law firm that has sued you and gotten a judgment, only then can they go garnishing your wages or levying on your bank account, all right? And it doesn't happen that quickly. It's not pay by Thursday or we'll levy on your bank account Friday or garnish your wages on Friday. It just doesn't happen, okay? There's a whole court process behind it. The only people that can garnish wages without an actual lawsuit are the federal government and the state of New Jersey, and usually when they're collecting student loans. I've run into that in my student loan practice, and there may be some other areas in which they can do what's called an administrative wage garnishment. But if this is a medical bill, if this is a credit card or something like that, ain't gonna happen, okay? If you've got a law firm on the other side, they've gotten a judgment against you and they need a payment, and they say they're gonna levy on your bank account, garnish wages, that could well happen. Won't happen Friday if you don't pay by Thursday, because the process, even after suit and judgment, doesn't act that quickly. But it can happen. So don't believe the debt collectors when they tell you that. And don't believe them when they tell you, if you don't pay, you can go to jail. No, it's a lie. There is no such thing as debtor's prison in New Jersey. Okay, you are. The only time jail can happen is if you do something later on in the process, failure to answer an information subpoena, which is part of a judicial process. And that is not jail for failure to collect a debt. That's jail for contempt of court. And nobody really wants to throw you in jail for that anyway. They just give you another copy of the information subpoena and say, here, fill it out. Okay, so really 99.9% of the time, you don't go to jail for not paying it. Don't believe them. Okay. They can't call you at inconvenient hours. Okay. Federal law, the Federal Fair Debt Collection Practices Act, regulates debt collectors. All right. And there are things they can't do. They can't harass you by calling you at inconvenient times. Now, it is presumed to be inconvenient if they call you before 8 o'clock in the morning or after 9 o'clock at night. Now, what if you work nights? okay, and you're sleeping during the day. Well, they don't know that unless you tell them. That's why it's presumptively between 8 a.m. and 9 p.m. But if you tell them, hey, I work nights, I'm sleeping from 9 to 5 instead of working 9 to 5, call me at night, then they have to call you at a convenient time for you. So they can't do that. They can't call you more than once in the course of a day. They call you, you talk to them, say I can't pay or whatever it is, and hang up. They can't call you back later in the day. Can't keep calling you. Again, it's a form of harassment. They can't call you at work if you tell them not to. And telling them not to, quite frankly, I would do it by letter, not verbally over the phone. And even better, do it by certified mail. Make sure they got it. Tell them, don't call me at work, because obviously it can cause problems with your job. So they can't call you at work. They can't do that. So there's certain things. And again, if you ask them, if you don't recognize the name of the creditor and you ask who the original creditor is, they have to tell you. It's part of that verification of debt process. So the next thing is, that's a debt collection. And again, the sooner you try and make a deal, the better. Work out some payments. Go through. Now, it can depend on, do you have problems with just one debt, or do you have a whole bunch of different creditors that you've got to deal with? Obviously, dealing with, in order for this to work for you, if you're dealing with one, you have to deal with the others. And now you're going through making a budget, trying to figure out what you can afford to pay overall towards your debt every month, then trying to work out a monthly payment with each creditor that's closed end over a finite period of time, so you know when it's paid off. And are the totals of all those payments to all those creditors added together affordable in that budget? And I talk about that in I believe it was a prior episode of my Financial Freedom podcast, and I'll put a link to that below so you can take a look at that, because that's a whole other process in creating a strategy to deal with creditors. You need to work it out. Now, if it gets to the point where they do send it to a law firm and they are suing, again, don't stick your head in the sand. Don't ignore it. If the law firm calls you, take the call and talk to them. If they send you a letter, if they send you a lawsuit in the mail, okay, don't look at it. Don't round file it without looking at it. If it's a letter from a law firm, you really should give it your attention. If you open it and it's a lawsuit, then the clock is ticking. You got to do something. Don't think that because you got it by regular mail and you didn't accept the certified mail that they didn't really serve you. No, there are court rules in the state of New Jersey that can, under the appropriate circumstances, allow for service by mail. So don't assume automatically that if you didn't accept the certified mail that they haven't really served you. If you got the regular mail and that went through and didn't bounce, that can be considered good service. So consider yourself served in the lawsuit. So try and work something out. Reach out and be proactive. All right. It's better to make a deal with the creditor before judgment is entered. Okay. There are some reasons for that. Number one, once a judgment's entered, it can be if the debt collecting attorney takes the step, recorded as a lien against real estate. If you own your home and they record that judgment as a lien and you go to sell that home or you go to refinance it, that judgment's going to pop up. And that creditor's law firm attorney's going to be sitting there with a handout to get paid. So you want to deal with it before it becomes a judgment. Another thing, and this is to bear in mind in general when dealing with creditors and making deals, if they agree to take less than what is owed, let's say they owe, just for round figures, they say they claim you're owed $10,000. Tell you what, if you pay $6,500, we'll call it even. You won't have to pay the other $3,500. Great, till tax time rolls around, and they send a 1099 to the IRS saying they forgave $3,500 in debt, and the IRS considers that income and may expect you to pay taxes on it. And that can be a surprise you don't want in the spring. All right. if you settle it with the creditor, you may, okay, you got to take the appropriate steps, and it's not that simple, be able to document it as a settlement of a disputed claim. When I handle and negotiate deals for clients, it's part of my practice. People come to me and they're being sued, and they've got this creditor coming after them, and they retain me to negotiate a deal. And if a judgment hasn't been entered, what I do is I make arrangements for monthly payments usually, or something like that, set forth in a document called a Stipulation of Settlement. And that document gets recorded with the court. The court says this case has been resolved. A judgment is not entered, so there's nothing can be recorded as a lien. It doesn't cause problems with real estate. And you're making those regular payments, and as long as you make those payments, they can't do anything, and judgment isn't entered. And if you end up paying the full thing, you do what you're supposed to do, make the payments, they ultimately dismiss the lawsuit. What you can do, and what I have done in that circumstance, is I put into the Stipulation of Settlement, well, now, this was a disputed debt. We didn't pay this because, yeah, we owe it, and we're going to pay it, and we're going to pay $6,500 instead of $10,000. We disputed the amount owed. We don't think we owed $10,000. But we didn't want to go to all the expense of an attorney and everything else, and going to court and trying a case and spending that money and running the risk of losing and having to pay the $10,000 anyway. So to avoid the cost and risk of litigation, we're paying the $6,500, but we don't admit we owed the $10,000. All right. Then you have that in a court document. It's a public document. It's been recorded in court. If the creditor, when it's all said and done, the case is over and you've paid the money, issues a 1099 to the IRS for the $3,500. The IRS comes to you. You can say, that's not debt forgiveness. That was a settlement of a disputed debt. Now, I'm not a tax attorney. I'm not an accountant. All I can tell you is that preserving that in a Stipulation of Settlement is a strong proactive move that you can make in an attempt to minimize the risk of that tax liability. And that's what I put in there, but I always warn my clients that could happen. So if you settle it before it's a judgment, you have the ability to at least try and preserve that. If it's a judgment and you're settling on a judgment, there's a court document that says you owe the $10,000. There's no risk of litigation or cost of litigation. There's a judgment that says you owe the $10,000, and the creditor decided to take less. It's going to be a lot tougher to avoid that tax on the debt forgiveness income if there's a judgment. Now, the only exception to that, the IRS will not tax you for the debt forgiveness income if you're insolvent. Okay, so you didn't pay it, you paid a lesser amount because you're insolvent and you couldn't afford to pay it. Then what I recommend people do is that when they file their tax return, say you resolve the case, made the deal in 2019, this year, and you paid them the $6,500, they gave the $3,500, and in January of 2020, they file a 1099. When you file your 2019 tax return, talk to a tax professional, fill out an IRS Form 982. That's the form that is used to provide the information to the IRS to demonstrate that you're insolvent. If they agree that you're insolvent based on the information in the Form 982, then they can say, okay, it's not taxable. The only thing you can't do is settle yourself out of insolvency. In other words, if the deal that you made you solvent, you're not really insolvent. But again, I'll leave that to the tax professionals. If you make this deal, when you do your taxes, talk to your accountant, see about filing a Form 982. The worst thing they can say is no. But if they say yes, you're insolvent, you can avoid that taxes. So it's a step you want to take. It's really a tax planning issue. So the other thing is, don't assume that there's nothing you can do. A lot of people say, well, I owe the money. What am I going to do? They're going to come after me. This is going to be a problem the rest of my life. It may not. Okay. I mentioned debt buyers. Some debt buyers have a real problem. They may have a real problem collecting the debt. It may be too old. They may have bought an old debt, and hopefully you don't notice, and they'll be able to collect it. but they actually can't sue and they bring suit, you may be able to raise the statute of limitations. You have to raise it. Court won't kick it back. But you may have a defense. Talk to an attorney. See if you have a defense. Maybe there's a statute of limitations and you can block the suit. Maybe they can't prove that they bought it. We're talking about a debt buyer. They have to be able to prove that they bought that debt from the original creditor. And if they can't prove that they bought the debt from the original creditor, then the judge is going to look at them and say, well, what are you doing in court? You're not the creditor. You can't prove that you got the debt from the creditor, that you're now the creditor. You don't have what's called standing. And if they can't prove standing, then they can't prove that they can't maintain their case. So there may be a problem there. There may also be a problem where they bought the debt, but they don't have enough documentation to show that you do owe it, to prove their case. They still have to prove their case. There may be some issues there. So just be aware that, talk to an attorney, an experienced collection attorney, to see whether there are defenses. Don't assume there's nothing you can do. But do that after you're served with a lawsuit. If you let a judgment be entered, then you may not be able to do anything about it. In New Jersey, if the judgment was entered by default within a year, you're usually able to reopen it. After that, it can be a lot more difficult. So what I'm saying, don't ignore it. It's best to deal with it within that 35 days, within that period of time that you have to file an answer, to deal with it, to reach out, talk to the attorney, either yourself or hire an attorney to negotiate it for you. Because really, sometimes you also, there may not be a problem with the claim itself, but they may not be able to, the creditor may not be able to collect in the fashion in which they may like to. In other words, you may say, well, I can pay $250 a month. And they say, no, we want $500 a month. Well, realistically speaking, the only way if let's say you don't make a deal and they get a judgment, they start levying on things, they garnish your wages. And in New Jersey, and there's a whole formula, and again, talk to a lawyer about this on your situation. But in the majority of the cases, a wage execution will take 10% of your gross wages. So let's say you make $3,000 a month, okay? That's $300 a month. Well, they can want $500 a month all they want, but they're not going to get it if they try a wage garnishment. Okay, they're bluffing. They're trying to get more out of you than they can take by force. Okay, I had a situation where I made an offer of $600 a month. The creditor's attorney came back and said, my client, it's a huge amount of money. He wants it paid faster. He wants it at $1,000 a month. And I told the attorney, I said, look, in order for you to get $1,000 a month, my client has to make over $120,000 a year, and he doesn't. So be realistic. Tell your client to manage their expectations, and because they're not going to get $1,000 a month. And the attorney ultimately agreed with me, and we made a deal for the amount that my client had proposed, because you can ask for it, but realistically speaking, you may not be able to get it. They may not be able to garnish wages. For example, you may live here in New Jersey, but you work in Pennsylvania. Pennsylvania doesn't have a wage garnishment for anything other than alimony and child support. Again, I'm not a Pennsylvania attorney. That's my understanding of the law, but that's been the case in negotiations what I dealt with, where they may not be able to garnish the wages. Sometimes, if you work for an employer, for example, if you work for a bank and you work in one of their branches in Philadelphia, but they have branches in New Jersey, well, the creditor can serve one of the New Jersey branches, still get the garnishment. Even though HR and payroll may be in Pennsylvania, as long as they have a New Jersey presence, I've seen that be successful in collecting a wage garnishment. But if you're just working for a company in Pennsylvania that has no presence in New Jersey, they may not be able to reach it. Okay, maybe the only thing you have in your bank, maybe you just have Social Security as your income. Can't garnish on Social Security, can't levy on it in a bank account. If you get a state pension, a fixed amount of money every month from a pension fund, can't levy on that. They can't levy on unemployment benefits. There are certain things they just can't garnish or levy on. So they may not have the ability to collect from you the hard way. And the only money they're going to get is from you voluntarily because you're trying to work out the debt. So you may have leverage you don't realize you have. So again, it's important to, depending upon the amount of money involved, it might make it worthwhile to talk to a collection defense attorney to see what can be done and what kind of deal you can make out. But only if you're proactive about it. The next thing is know when to give up. Okay, I've seen people do drastic things to avoid filing bankruptcy. They have debt that is just unmanageable. They're never going to be able to pay it off. Credit card debt at default rates of 25% interest or some such thing as that. Just insane. And they have $15,000, $20,000, $25,000, $30,000 or more in overall credit card and medical debt. And they just can't pay it. All right? Sometimes it's okay to give up and just file bankruptcy. But I've seen people empty their pensions and take on second mortgages they really can't afford to try and pay off this debt because they're trying to avoid bankruptcy. Sometimes bankruptcy is the best thing for you. All right? Take a realistic look at your debt. If you can't pay off your debt in 36 months, a realistic period of time, 3 years, consider bankruptcy. Look into it. Take a look at your credit scores, all 3 credit scores. If the credit score, and I'm not a credit counselor, but in my experience, if that credit score starts with a 5, not much worse things can get with a bankruptcy. And quite honestly, ask yourself this question: Would anybody lend you money now? And if the answer is no, again, what do you got to lose? Get rid of the debt that's the anchor around your ankle. Okay, get rid of that debt. Work to improve your score and improve your credit situation after that, and let bankruptcy take care of it before you start doing things like gutting your pension or taking a payday loan or a car title loan to try and pay your debts. It's just not the right way. Talk to a qualified bankruptcy attorney. If you're here in Southern New Jersey, I'd be happy to talk to you. Same thing as if you want to work something out with a creditor, happy to talk to you. But if not, just talk to a qualified attorney in your area and deal with it. And that's the most important thing. So that's it. We've been on for half an hour. Try not to run longer than that. You got to get back to work. It's 1 o'clock. Put down your lunch. Hopefully you've been eating it while watching it and move on and get back to work. Lunchtime's over. But if, like I said, it's on Facebook. If you liked this video, please hit the thumbs up button. It helps Facebook's algorithm get more reach, shares it to more people. Affirmatively share it, as I said earlier in the video. If you like this, hit the thumbs up button. You share it with other people. Now, I realize because of the topic, you may want to do that discreetly. You can share it in Facebook Messenger and do it that way rather than put it on someone's wall. But spread the word. All right, get the information out there to people. If you're watching it on YouTube, then hit the thumbs up button as well. Lots of likes, again, helps the YouTube search algorithm, helps get the word out to other people so more people can see the video. And if you have a topic you'd like to suggest, leave it in the comments to either the YouTube video or to the Facebook video. I'm always looking for new topic ideas. And finally, if you like the content on my YouTube channel, feel free to subscribe by clicking that blue R button, and you'll get notifications. But that's it for Lunch with a Lawyer, and I'll see you next month.